Hi guys, it's Kathy. I hope you're doing well. I hope my microphone's okay. I was doing stuff. Mm. So we got trial with Judge Fleischer today. It's pretty good. It's entertaining. It's short. It's very short. And we got the greatest withdrawal of a withdrawal. And if you're confused, it's nothing. Okay, I'm not going to say that. I was going to say if you're confused, it's nothing to how confused he is. But I'm not going to say that because I watched it a couple times while I've recorded it, heard it, then edited it, heard it, recorded it. I don't think he's confused at all. The more I think about it, I don't think that he is at all confused. But Kelly, stop. Knock it off. I want to hold the beers. Oh, wait, look. I'm holding a beer. Mm, Hefeweizen. It's really good. It just tastes good. So I didn't have to worry about dinner tonight. I worked. I got home. It was already here. Fozzie sent me some pizzas with green stuff on it. Fozzie, I'm so proud of you. I'm so proud of you for doing that. Putting green peppers. They were so good. It was on a thin crust, pepperonis, peppers, sausage, and then a regular, like, not thin crust, not thick crust, regular pepperoni. I didn't have to cook for my kids, which they're really adults, but it was so nice. And then remember, Fozzie said the other day that he found Pez in his daughter's room when he was helping her move? He sent me some Pez, right? A bag of Pez with all types of flavors in it. So I carefully pick out one of each color for my middle child. My middle child is a lot like me, but so we have bingo tonight at work. She's the bingo color, and we're always late for work, so we're getting ready, and I'm like, we're going out the door. I'm like, open your purse. She goes, why do I have to hold something? And I had them in my apron because I had my own stash in my apron for work tonight. I was eating Pez all night long. I didn't share, not one. Well, except for this part. So I grabbed one of each color and I give it to my daughter while we're running to the car, and she says, she says, Mom, these are Pez. I said, yeah, I know. I don't have a Pez dispenser. What do you think I am, a heathen? I'm just supposed to eat these like that? She, she was so offended that I gave her Pez without a Pez dispenser. So I'm gonna get her one thing for Christmas this year. One. I'm gonna go and find a Pez dispenser from like Goodwill or something. Find it in someone's basement. It's not even gonna be a new one. It's gonna be a, who I think I'm gonna give her? I'm gonna give her the Green Lantern if I can find it. A Green Lantern Pez dispenser because that movie really was bad. Ryan Reynolds, it was not good. She loves comics, so I'm gonna give her a Green Lantern because it was just a bad movie, and we joke about it because we love Ryan Reynolds, of course, obviously, and we love comics. But you found a giant size Pez dispenser. They are a little too tiny. The little Pez's you put in your mouth. It's like one little tiny little piece. Oh, it was funny. It was so funny. Yeah, that's my daughter. So 3 feet tall. You found a 3 foot tall Pez dispenser. Do they make like bricks of Pez? I mean, I guess in America we make oversized everything, everything oversized if it's bad for you. We don't have oversized carrots and celery at the grocery store, but man, you can get an oversized chocolate bar this big. Chocolate. So let's go ahead and yes, CJ, you're first. Let's get started. This guy. Oh, you're gonna love this clip, I'm telling you.
Mr. Calhoun's here, I think. We gotta find him.
Whoa, Judge Reese. Why are you screaming at us? What did we do to you? Why don't you calm down? Everybody fix their volume. You good? I'm pressing play.
I just did. All right, Mr. Calhoun, we got Mr. Gates is here on the
my goodness
online. You have a motion, I think, to withdraw a guilty plea. I'll hear your evidence at this time.
Judge, as my understanding, based off conversations with my client, that he no longer wishes to proceed. However, I will let him discuss that with the court. I'd prefer to have him tell the court that if I'm have a misunderstanding, then I apologize.
See, I would have actually preferred, the line was disconnected, we were discussing it, but
I'll be quiet, please.
I don't have enough legal knowledge to actually get my point across clearly and respectfully in the courtroom, so I would like a chance to speak with my attorney and have him actually represent me and speak for me as needed.
Well, your attorney says he has spoken with you and that you have told him you wish to withdraw this motion to withdraw your guilty plea. Is that true?
I have put in a motion to withdraw the plea because I don't remember pleading. I don't remember the plea in the Downey situation, not all the way clearly.
You don't remember the Downey situation. I don't know what you mean, Mr. Yates.
The whole court proceeding. I thought it was attempt to sell a controlled substance. Then he said I was dirty urine. I didn't know whether I was in a probation revocation or whether we were dealing with a new charge. Well, I didn't talk to him until 5 minutes before we entered the courtroom. That was our first contact.
All right, that's not the question at this point. You're arguing. Hold on just a minute.
Yes, sir.
You're arguing the motion now, and that's fine later. The question,
do you
right?
understand, Judge Reeves, I haven't had a chance to talk with my legal counsel about what the problem even is because the line got disconnected.
Well, your lawyer says he's talked to you, Mr.
So if I say it didn't, I mean,
Mr. Calhoun, hold on, Mr. Gates. Calhoun.
I have spoken with him. That was my last understanding. I think the line was disconnected, but my understanding was based off our conversation that he would withdraw the motion to withdraw. Now, again,
yes, yes, sir.
You're wanting to withdraw the motion to withdraw, so you don't want to pursue it any further, correct?
I want to withdraw the motion. I think I'm not a lawyer. I don't even understand what I don't want to say something important and be stuck and be confused on it later. That's what the problem was with Mr. Down. I didn't have no understanding. Don't even remember the court date.
Well, if you withdraw the motion to withdraw your guilty plea, then it won't go forward and it won't be heard. And the guilty plea.
It's not what I'm saying. My only concern was I wasn't done talking to my lawyer.
Mr. Gates.
I want to withdraw my plea.
Mr. Gates. We're going to have a very fundamental problem if you keep trying to talk when I'm talking.
Okay, I apologize, Judge Reed.
Yeah, now I will let you have a chance to speak fully whenever you need to be heard. But I wanted to make sure you understand, and I was trying to explain something very important to you, and then you started talking.
The computer chopping just a little bit. Too,
I understand.
Right? It's gotten a little clearer though, Judge Reeves. I can hear you.
Yeah, that doesn't explain why you keep talking while I'm talking. The computer being choppy doesn't cause that to happen. Now, here's the deal. If you withdraw your motion to withdraw your guilty plea, then that motion will not be heard and the guilty plea will stand. That's the bottom line.
Yes, sir.
Now, your lawyer says you told him you wish to withdraw your motion. You just said...
I never said that.
Well, you just said that a minute ago that I want to withdraw the motion.
I said the plea. I want to withdraw the plea.
Okay, then we'll go forward with the motion.
All right. Okay, that's,
If he wants to withdraw the plea, we'll go forward with the motion to withdraw the guilty plea.
so just so we're clear, he wants to proceed with the motion to withdraw.
That's what he said.
All right.
Okay. I am confused. I am, because we keep saying what I am confused. And are we withdrawing?
Are we what?
We're withdrawing the plea, right? I'm not guilty.
No.
I'm not guilty of anything.
Well,
I was even committed.
No, sir, we're not withdrawing the plea. Your lawyer is going to argue, and he may present evidence asking me to allow you to withdraw your plea. But
Yes,
that's
sir.
a decision I will have to make after I hear the evidence.
Okay, I get that, Judge Reed. I
Right.
mean, because
How many of you think he already made his decision?
my encounter with Mr. Downey was brief, only 5 minutes before. I don't think there's any cameras or audio in the room that we talked in, so I'm not sure if there's any evidence, Judge Reed.
Well, I hope there's not any audio or camera in that room. There's not supposed to be. When the lawyers are talking to their clients, there's not supposed to be any cameras or microphones in there because that would violate the attorney-client privilege. And so I hope there's not anything in there, but there is evidence to hear. Mr. Downey can call Mr.
So here's just a real quick summary of what's going on. This guy is in prison. He says for 15 years. It's not. It's 15 to serve 5. All right. So he pled. He took a plea. 15 to serve 5. He pled guilty. And now he's in jail thinking, wow, I shouldn't have pled guilty. I don't want to be in jail. I don't want to be here this long. I didn't think I thought I was going to get probation. But no, he's in jail. So now he's saying that he didn't understand what was going on at the time of the plea and blames everything on his lawyer. Everything.
Mr. Calhoun can call Mr. Downey to testify. There is the record. You see, there's the record that was made. There's a transcript that I have, in fact, reviewed where I gave you advice about all your rights, told you about all your rights, and told you about what the recommendations were and all of that, and you answered all those questions. And there's a sheet that you filled out or somebody filled out and you signed, and I asked you about it. There's lots of evidence with regard to your guilty plea. So let's go forward with the hearing. Mr. Calhoun, you may proceed.
All right. Thank you, Judge. I'm going to go ahead and waive open you. That's okay.
Fine.
Judge, I'd like to call Alex Downey.
Please raise your right hand to use for the testimony you're about to give in the case now in hearing be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, please have a seat. Make sure the microphone's close to you so that we can hear you as well as Mr. Gates being able to hear you.
Good afternoon, Mr. Downey. Could you state your name for the record, please?
Alex Downey.
Okay. And did you represent Mr. Gates?
I did.
Okay. And what did you represent him on?
I believe he had a probation revocation and he had some pending new charges for drug sale of some sort.
All right. And do you recall speaking with Mr. Gates?
I do.
All right. And did you advise Mr. Gates that he was there not only on a probation revocation, but also on 2 other counts?
I did. We spoke about that.
All right. How long did you speak with Mr. Gates?
Let's see. I know that, and I apologize, I didn't get any notice of this. I would have brought my file otherwise. I typically take notes. I know that I arrived here in Emmanuel County from another court. We spoke in the client attorney interview room in the back for, I would say, 5, 10, 15 minutes. More than 5, I'd say 10, 15.
And did Mr. Gates appear to be under the influence? Did he understand what you were saying?
He didn't appear to be under the influence. We discussed a strategy to do a wrap-up deal. So we talked rather at length about the advantages of that. He understood that.
So if Mr. Gates, had Mr. Gates been in rehab previously?
Had he been in rehab?
Had he previously been in rehab, or do you remember?
I don't recall.
Judge Reeves,
Yes, sir.
when we did meet,
Mr. Gates, hold on just a minute. This is not your turn to talk. This is your attorney's time to ask questions of Mr. Downey. So don't be interrupted. All right.
All right. And so, did you advise him of the risks and the problems with the wrap-up deal?
Yeah, we spoke about that and the advantages as well.
Did he appear to have any issues with that, or did he have any questions that he had or asked or anything like that?
I know he had some questions that we discussed. I can't recall exactly what they were off the top of my head, but we did speak about a revocation. I believe he had been revoked in the past by Judge Reeves. I believe I recall speaking to him about that when I was discussing with him whether or not he understood the revocation process, to which he indicated he did understand the process.
And did you review the evidence with Mr. Gates before the wrap-up offer was presented, or did you have a chance to go?
We spoke about the evidence. I didn't bring my computer into the room for that, but we spoke about what evidence the state had alleged against him and the events that occurred.
Did you feel that Mr. Gates understood what you were talking about?
Yes, I do. We spoke about the evidence for a revocation hearing and evidence for an actual trial, and he seemed like he understood both concepts.
Okay. Did you have any reservations about him taking the negotiated plea deal?
No, I thought it was in his best interest.
No further questions, Your Honor.
Cross-examine.
Thank you. Mr. Downey, did you know that you were going to be testifying here today?
No idea.
Do you have your case file with you?
I did not.
Have you reviewed it at all since the sentencing in this case?
I have not, other than I went over it once whenever I sent the material to Mr. Calhoun.
So your testimony here today is based off of your recollection of your memory of what you did with your client and what happened at court.
That's correct.
Okay. Of course, this is a motion withdrawal guilty plea. When you met with Mr. Gates regarding this plea, was it just on this case itself, or did he have other matters before that?
I can't recall exactly how the calendar was stylized. I know I originally came to discuss the revocation with him. That conversation at some point turned into a wrap-up plea discussion.
So that day, he was actually scheduled for probation revocation hearings.
That's my understanding. If he was scheduled for something else, then I don't recall.
Okay. And when you met with him, did he ask for a wrap-up offer?
I can't recall how it came up. If I can recall correctly, I went in and out of the room maybe once or twice, I believe, to discuss the wrap-up offer with you. But I can't recall exactly how the wrap-up offer came about, other than the fact that we eventually discussed that.
Well, let me ask you this. Did you force Mr. Gates in any way to plead guilty or to admit to anything or to have, to do anything to get sentenced that day?
No, he didn't have to plea at all that day.
Make any threats to him in any way?
No.
Did you make any promises to him in any way besides what the negotiated sentence was?
No, none.
Did he seem to understand what was going on?
Yeah, I can recall he asked about basically the burden of proof for a revocation hearing. But aside from that, I can't recall any other questions that he specifically asked me, but he had an understanding. I discussed the process of pleading with him, and there weren't any red flags that came up for me in our conversation.
And did he appear to be sober?
Yes, he appeared to be sober.
Any slurring of speech or
Hey, Tina P. Am I wrong? I might be wrong, but I don't think I am. I think you've been a member for 6 months right now. Is that right? Six months? I think you've been a member for 6 months, Tina P. Yay.
or anything that would indicate that there was some type of intoxicant or something that he wasn't understanding of what was going on?
No, I found him to be very coherent, pleasant, actually.
He asked you questions about the criminal court process?
Yeah.
He asked you questions about burdens of proof?
He did.
He asked you questions about the case and your understanding of what he was looking at?
Yeah, he did.
And you answered all of his questions?
I did.
Was it...
He may have asked a question about what prison or what prison he'd go to. I told him I don't control that. There's no one here that controls that. I think that was a question that he asked that I was unable to answer.
which would go to you didn't make him any promises that you weren't 100% sure about, right?
No, I didn't make him any promises.
Right. And so did it ever get hostile or aggressive that made you concerned about moving forward with the wrap-up plea that was done on that day?
No, like I said, I actually found Mr. Gates to be pretty pleasant.
Did you have any concern at all about Mr. Gates pleading guilty on this case on that day?
No, none.
I got no further questions.
Just one I've got here from the actual clerk's file, and I'm going to let this remain in the clerk's file so it won't be a separate exhibit, but it's called a sworn statement of defendant. So that is from the clerk's file. You familiar with that?
Yes, sir.
And is your signature on that?
That is my signature.
All right. And did you go over that with Mr. Gates?
Yes, sir, I did.
And did he provide you the answers that are shown there on the form indicating that he understood those rights?
Yes, sir, he did.
Did he ever indicate that he did not understand any of those rights?
No, sir, he did not.
And is that where, did you see him sign that in front of the clerk? Deputy clerk?
I can't recall if he signed this in the back room and then he swore that was his signature or whether or not he signed it up front.
But he signed it.
Yes, sir.
And either signed it in front of the clerk and swore it was his, and swore to it in front of the clerk when he signed it, or he signed it and then swore to the clerk that that was in fact his signature and that he understood all of his rights.
Yes, sir.
Right? All right. Thank you, sir.
I'm so confused, by the way. If anybody, which one is my lawyer?
Well, Mr. Calhoun is now your lawyer. Mr. Downey was your lawyer at the initial hearing, but when you filed a motion to withdraw your guilty plea, Mr. Downey had to withdraw because he cannot represent you on that matter. And then Mr. Calhoun was appointed to represent you on the motion because Mr. Downey was your lawyer at the hearing, and Mr. Downey certified to the court. He stood before the court and said, yes, sir, this man understands all of his rights. And, you know, he's asked that very question. So he has told the court that you understood your rights and that it was a valid plea. So he can't then challenge it.
I'm telling you,
There you go. There you go, talking when I'm talking again. But you don't want to hear what I've got to say. Go ahead and talk.
Okay, thank you. Because I'm confused about what's going on, and every time I'm confused, I end up getting a lot of time. Now, he's lying. That's my face. You can turn around and he's lying. He told 5 years. I wouldn't do the whole 5 years. I remember that. I don't remember signing nothing. I don't remember multiple signatures. And just listening to him, he don't know nothing about my case, what I was charged with, how long, when he got there. Only thing he knows is that I knew everything and I wasn't under the influence. I don't even know.
All right, thank you.
Because I would have been upset just as now when I realized that it wasn't attempt to sell drugs and it was attempt to commit a felony, something I've never even been charged with. I got upset. So right then I would have been upset.
Well, you were charged.
No crime was committed. No crime was committed February 26th.
This is a guy. Listen to it. I think this is the part where the judge tells him exactly what happened, and it's hilarious.
Second.
You were charged with attempting to commit a crime, that is, sell drugs to, I believe, either an undercover or a police officer, I believe. After you had communicated with someone about selling drugs, they turned it over to the law enforcement. The law enforcement then pretended to be that person. I believe it was a female officer, Buffy Snellgrove, I believe, and they turned it over to her for her to complete what you thought was going to be an illegal transaction with a teacher or somebody else that you were communicating with, and that she then went and met with you, and apparently you recognized her and did not complete the transaction, but the evidence at the hearing was that you had attempted to do that. That's what the evidence showed at the hearing. Hold on just a minute. Any further questions of Mr. Downey after the questions I asked? Did that bring up any additional questions on behalf of the state?
No, Your Honor.
On behalf of the defendant?
No, Your Honor.
All right, thank you, Mr. Downey. You may step down.
Thank you, Judge.
Anything else, Mr. Calhoun?
Your Honor, I would call Mr. Nico Gates.
Mr. Gates, please raise your right hand. Nico Gates, raise your right hand. Do you swear the testimony you're about to give in the case now in the hearing be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Put your hand down now. Please answer any questions that either of the attorneys ask you. Please let them ask the question before you start talking. You have a tendency to want to dominate the conversation.
Who thinks he's going to let them finish their question before he starts talking? Who?
And talk while I'm talking and while they're talking. I can't understand what's going on and can't give this matter proper consideration if you do that. Mr. Downey, you may proceed.
Sir? Mr. Gates, do you recall entering the plea? Do you recall entering a plea on the 24th day of April of this year?
I don't remember the court date very well at all. It's bits and pieces, and I'm not sure why. I keep telling y'all I'm confused, and I know no one wants to help me. I don't know, man. I don't know what. I don't remember. No, I do not.
Okay. Do you recall signing any plea documents?
I remember going over some papers.
Okay. But do you recall signing?
Every time I don't know what I signed. I didn't agree to that.
You don't have
We
to
didn't
listen.
talk about that. We talked about attempts to sell drugs, selling drugs, and he told me drugs were found, and if I didn't take this plea, it's gonna be, you can give me my, did he say 20 years? But I didn't know whether that was gonna be a separate court date, but I'm confused.
All right. Have you you have a drug problem?
I'm a recovering addict. I mean, dibble and dabble, no more, no less than most people my age, I would, in my opinion.
Were you, is it your contention that you were on drugs on that date whenever you entered the plea?
Honestly, when I was arrested, I was placed in a holding cell pending investigation or whatever they said. I don't know what was in my system. My PO said I had drugs in my system. I don't know if she sent it to the lab where that can be proven. That's something I've been asking attorneys, where I can know what was in my system. Because maybe she knows whether I was under the influence. Or maybe, I'm not sure. I don't know what. I can't feed myself in there. I got to eat the food. I don't know what's being put in my system. What I do know is I didn't agree to 15 years.
Again, how many people think they drugged him in the prison with like fentanyl or cocaine
Because I ain't commit no crime.
in his food?
I just got 15 years. If drugs were in my system, this one I'm getting 15 years for. Because no crime was committed on February 22nd.
All right. And is it your contention that you don't recall signing plea paperwork? You don't recall the negotiation that Mr. Downey did for you?
I probably did sign the paperwork, but I wasn't fully aware of what was on that paperwork.
Okay. And if you were aware of what was on the paperwork, would you have signed it?
No, sir. Not 15 years. And next time I get in any trouble, I'll be type C recidivist. And this is a 15-year sentence and attempt to commit a felony. No, I didn't know none of that. I don't even know why I was arrested. I mean, my understanding was a probation revocation, a technical violation, because maybe new charge, but new charges are irrelevant because there's no evidence there. It's nothing. Ain't no drugs. I thought it was gonna be over with then. And I'm thinking Judge Reeves was gonna say, police, why did y'all find drugs? Why did y'all search?
Good morning, honey bear.
It's been housed illegally. Why didn't y'all have y'all body cam footage on when you got Mr. Gates? Why didn't you let him sell the drugs or whatever? I'm thinking about Reeves was gonna tell the police department, you didn't do what you needed to do. You didn't catch him in the wrong. He didn't have a chance to commit any felony. Right. So let's drop that and just deal with a revocation. I don't know what we went for. Wrap up. Beat the charge. I can beat the charge, and I'm not a lawyer because you didn't have any drugs.
Sounds like a felony.
So
beating something.
I didn't have any phone. I didn't text anyone. This is the thing that I need on court record. I'm confused. I need help. I didn't have any drugs. I don't know who was texting. I was sent to one spot to meet a friend at a specific time. When I realized that wasn't my friend, I left. Police everywhere. Next thing I know, we in court. We talking about 15 years. No drugs, no violence, no.
Mr. Gates, let's just focus on what we're here today.
I don't even know what we're here for. This is just, I'm not a lawyer. I'm not. Just withdraw the plea and help me or send it to someone who can help me, please. I apologize, but I don't have. I'm getting upset and I'm already confused and I'm not trying to drag this out. I'm letting you know I need help. I'm letting you know that whatever happened wasn't.
Are you telling the court that if you were aware that you would have gotten 15 years, you would have not signed the plea? Is that correct?
If I was aware that I was saying I was trying to sell drugs or any drug related anything, no, I wouldn't have signed that plea. I have nothing to do with drugs. I just completed a rehab not too long ago. I'm in recovery.
I got nothing to do with drugs. I just got out of rehab. His lawyer was just on the stand. Gemma, he was very straightforward, almost robotic like lawyer.
Sell drugs, use drugs willingly, anything like that. But if I'm that hazy about the situation, I'm sure something was wrong. I'm not sure what, but something was wrong.
All right. So if you gave testimony that day where you said that you were not under the influence and you did want to accept the plea deal, that was a mistake. Is that correct?
You saying if I did, like, did I do it? Did I like? If I did, then that was a mistake. I didn't. No, I'm not trying to admit to selling drugs. I don't sell drugs. I don't use drugs anymore.
And it's your contention that you were under the influence that day. Isn't that correct?
That's the only thing that would make sense. But then again, I'm listening to him say we were there 5, 10, or 15 minutes. It don't seem like he knows. It seemed like maybe we were on drugs or something. He don't know what I was charged with, what the recommendation was, what we talked about, when he got there, where court he left from, whether I signed it there or here. He just confuses me. I'm telling y'all we need help.
Judge, it's not my fault. My lawyer was on drugs. It was my lawyer that did the drugs, not me, Judge.
I need to get back in court with a lawyer that's competent. I'm in Bobby Reed's courtroom. I'm in the lion's den. I need help.
All right.
I need a lawyer that's competent.
And it's your contention that you weren't competent that day in order to make the plea. Isn't that correct?
It does. I'm sorry. And it does break up every now and again. Just repeat the question.
So are you saying to the court that you believe you weren't competent that day based off the fact that you believe you're on drugs and that you didn't understand what the plea was? Is that correct?
Yes, sir.
Okay. Are you asking the court to withdraw the guilty plea?
Not just asking, but I'm asking humbly. I am upset, and I know I do get out of pocket sometimes, but it's my life I'm fighting for. Yes, Judge Reeves, I need you to consider the fact that it's too much confusion in this.
Mr. Gates, let me get done asking questions, okay? Mr. Gates, now did you have a chance to review your discovery?
No, sir, I haven't gotten anything.
All right, hang on. Mr. Gates, if you'd had a chance to review your discovery, do you think you would have made a different call? you would not accept the guilty plea.
Yes, if I knew everything that I know now, that it would be a totally different outcome. If I had any other lawyer, I feel like it would have been an outcome. If I could have spoke with my lawyer a day or two in advance and had time to prepare questions and him to have time to prepare intelligent answers, then I'm sure we would have.
Every time he says something about his lawyer, I just want to punch him. But that's illegal, so don't punch people.
Got a different result in 15 years.
And it's still your contention that on that date that you believe you were under the influence of some intoxicating substance. Correct?
Yes, sir. That's the only explanation for not remembering my whole court proceeding with my life involved.
Okay, and so whenever you were present in the court, you answered questions under oath, you don't recall that, correct?
I don't recall the court. No, sir, I do not. I do not recall the day. I don't want to be held accountable for nothing that happened that day because I'm so hazy on that day. So anything dealing with that day, I am confused.
Deborah, I am so sorry about that. My dad had ALS, so he couldn't fight it. There's no cure. So I watched. So I understand. Go into Discord and talk anytime you want to. Anytime.
Don't give me more time for lying and I didn't remember to lie. I won't get caught no lie. I won't help. I won't fear.
All right. Today, are you under the influence of any intoxicating substance?
No, sir.
All right. Are you coherent and understand what's going on?
Yeah, I'm a little confused, but yes, sir, I'm coherent. I'm trying to get some
You
understanding.
ain't confused.
Yes, sir. I'm coherent and I'm searching for understanding. And I'm getting asked questions, but I'm the one confused. I have more questions than answers, I assure you.
All right. Is there no further questions, Your Honor?
Paul, you make
Thank you.
gentlemen.
Mr. Gates, my name's Aaron Palmer. I'm an assistant attorney here in Emmanuel County. I'm the prosecutor. I was the prosecutor that handled your sentencing hearing. What do you think? What do you think your sentence was?
I'm not even sure. Listen, I'm sorry if I'm frustrating y'all because I'm not answering questions, but I keep saying I do not know what we.
Repeat that. I didn't catch that.
I do not know. I don't know. I thought it was going to be definitely less than 5 years when we dealing with a probation revocation. From what I understood, a technical violation wouldn't lead to nothing but 2 years.
What do you think the violations were?
I remember my PO coming, and she said all kind of stuff was failed on the test. I'm sure when it got sent to the lab, it was different because she named substances that I don't even know how to get to. Morphine and benzodiazepine. I don't even know what them is.
Okay. Well, what was your recollection of what happened when you were in court back in April?
I remember being in court, probation revocation, and my lawyer being late. He's not gonna do 5 years, probably round off to 2. You ain't gotta worry about these charges. If you don't take it, you can get 20 years. It's foggy, man. It's foggy, man, but
Sounded like you remembered.
I didn't know I had 15 to 5, no drugs, evidence, no guns. I ain't hurt nobody. Who's gonna just let him? I just got 5 years to spend. Who gonna take? No person in their right mind takes 5 years with nothing for nothing.
Well, I guess what I'm trying to get to is why you're trying to withdraw the plea.
I'm trying to figure out. I'm trying to withdraw the plea because I didn't have time to. I didn't 15 to 5. I've gotten another conviction for some drug related something about selling some drugs, and I didn't sell no drugs. That's why I don't need nothing dealing with drugs on my record. I don't need that. I don't remember doing that. I don't. This is what I need. I don't know what to. I need to get back in court. I've been dealing with Bobby Reeves. One thing I know, Bobby Reeves is firm. Definitely. It's been a couple sentences where I feel like it's harsh, but a lot of times I feel like it's fair.
Bobby Reeves, That's the judge. He's talking about the judge right now, calling him Bobby Reeves.
He's giving me 20 years first offender, but he's also gave me the opportunity to go to rehab and better myself. I need a lawyer to point out the fact that no crime was committed, that the police didn't find anything, because I don't even know if Judge Reeves knows this, because Robert Downey didn't tell him. Or if he did, I wasn't in the courtroom when he did. He didn't tell him that no drugs found on me, no money was exchanged.
No, you're right.
Phone.
Actually,
That's not even my phone.
Mr. Gates, you're right. Actually, I was the one that told the court that. I told the court that they didn't find any drugs on you because you swallowed them when you were being arrested. Right?
You sure of that? You were there? You got proof of that? And maybe, if, depending on how long drugs stay in your system, how long did it take me to get to court? Maybe they were still in.
Then why did you plead guilty to it?
I don't remember pleading guilty to it, sir.
Okay. So you're not actually upset in regards to the guilty plea. You're actually upset in regards to the sentence.
No, it's the guilty plea. I'm not guilty of, I don't even know whether, I've never even been charged with attempt to commit a felony. It's been synthetic drugs. None of those were found. Can't show no proof of that. Then it's been level 2 controlled substance. None of that. So what did I swallow? Show me a video where I swallowed anything, where I don't have a phone. You telling me I was texting someone and met someone? I don't have a phone. That's not my fault. I didn't have a phone when they arrested me. I don't know no school teachers. Been out of school 27. I've been out of school a long time.
And when you say you don't remember, were you under the influence of anything when you came to court on that day?
Not willingly, but I don't feed myself in jail. They locked me up and was giving me juice, grits, and apple juice. I ain't no telling what was in that stuff. Because if you lie about a drug test, depending on what, and I'm not saying my PO is out to get me. All I'm saying is it could be an expiration date. It could be anything. I mean, she could have misread it. What I need is proof. Y'all got proof saying, yeah, you got proof that you signed this paper. I don't know why I would do something like that, and I know there had to be something wrong with me. I need help. You say y'all need proof to get me help, but I need help.
Would you agree with me that if there was proof that you were the one that signed the paper, that the
I'm sure my lawyer, I'm sure Ms. Downey wouldn't just sign the paper. It wouldn't forge my signature. If the paper got signed, I'm sure I signed the paper. But did I understand the paper? No, sir. Would I sign it again? No, sir.
So that's not my question. Did you sign the paper? Or was it forged?
Whoa. I don't know who's making fun of grits or whatever you're doing about grits, but you let them alone. You let those grits alone. Kiss my grits.
I don't recall.
Okay. Did the judge sign the paper in front of you?
The judge?
Yeah, Mr. Judge Reed.
You mean Mr. Reed? Bob Reed?
Correct.
I'm going to object to that. That's vague. I'm not sure what
Objection.
he's talking about in
They're
terms of signing the
delicious.
paper. Is he talking about signing the order? I'm not sure if he's talking about signing the order or if he's talking about signing the paper for him. I mean, I think
I'm not sure either.
Well, a vague question. I don't think he can answer.
Judge, Mr. Gates just denied that he was ever in front of you and that his signature was forged by his attorney. This is the first I'm hearing about it. And Judge, you were a witness for the entire plea. It sounds like you're part of this conspiracy.
I never said it was forged.
He just told Judge that he was part of the conspiracy. Don't worry. The judge knows what's going on. Ready? Here we go.
Yesterday afternoon with you, I'll overrule the objection. You can ask him the question.
All right. Did Judge Reeves go over any questions with you when you were in this courtroom back in April?
I do not recall.
Okay. So you're not necessarily saying that it didn't happen. You're just saying you don't remember.
Correct. And the fact that I don't remember, hey, this is my life I'm dealing with.
No further
I don't know what took place. I don't even know who's helping me.
Listen, if I don't remember that something happened, then how can I be found guilty? How can I be found guilty of doing something I don't even remember I did? So there was a stream, I think it was about a month ago, when I picked on Fozzie pretty badly. Well, you know what? I don't remember when it was, so you can't fault me for that. I don't even remember that it happened, so I'm innocent, right?
You're representing me on the gray suit or the blue suit. I've never met with y'all. I know Judge Reeves, but I would like a chance to talk.
Corn. Grits are made out of corn, and they're like bigger than sand. They're hard. You have to cook them, and you have to let the water soak into them to make them nice and soft and delicious. But Fozzie saying that he doesn't like grits is Fozzie saying he don't like corn. I don't like corn, which we all know is a lie. Fozzie likes corn, so grits are corn.
The Judge Reeves, because this whole public defender, I see you shaking your head, and that's fine.
I can't do that, Mr. Gates.
Then tell me what you can do for me, Judge Reeves.
Well,
You
Mr.
giving me
Gates,
some time.
I'm
you giving me
afraid-
some opportunities. Help me.
I'm afraid there's not much at this point that I can do for you because you were in open court. All of these rights were explained to you on the record by me in detail. And you entered your plea of guilty after having signed the plea sheet in front of.
I remember him telling me I get 20 years if I didn't.
In front of the deputy clerk, and your defense today is that somebody at the jail drugged you involuntarily. That you didn't take any drugs, but they had to have something in your food to drug you so that you wouldn't know what you were doing. That's what you just said a few minutes ago.
That's a possibility.
I don't find that to be credible.
Judge, he doesn't remember saying that a couple minutes ago, so you can't find him guilty of that. He doesn't remember. Come on.
At all. That's just not credible. That's not something that this court can believe. Okay, any further questions?
Yeah, I have a question.
No, not for you. Whether your lawyer has any questions.
Briefly, Your Honor. Mr. Gates, is there anything that you would like the court to know that we have not already spoken about?
I want it on the record that I've been sentenced unfairly. I've been tricked. My lawyer told me I would get 20 years if I did not sign something or go through with this proceeding. I didn't even want to go through with the proceeding because I had a public defender. I wanted to wait till a court date. I was told Bobby Reeves may be on the bench, he may not. No numbers. This is what I do remember. I want the court to know I'm fighting for my life. No crime was committed on February 22nd. I need to know how to get back in court in front of Bobby Reeves or any other judge. I don't know whether I'm being attacked, whether it's personal, whether it's malicious. I don't know what's going on, and I feel like this court date is a formality. I've been given an attorney that's from right down the street. I'm sure everyone in this courtroom knows each other personally. I'm fighting for my life, and I'm going about it the right way. I don't want to be rude. I want to be humble. I want to be respectful. But I want you to know that I'm dead serious. I don't appreciate it. I know my rights were violated. I know my people's house was searched illegally. I know I was tricked into this plea. I know that no judge looks at that. No, they have no evidence. So if y'all told Bobby Reeves I have no evidence, Bobby Reeves fair. I don't think he would have just said, "Yep, convict him, extra felony, no drugs, nothing." You can just give him a felony. Why not? It's old Nico. So I don't know what went into play. I don't know what went in the mix. I don't know what gears are working, but I know somebody was out to get me. Sent me to a store with a bunch of police. All of a sudden, they come out, we know you swallow drugs. No evidence, can't prove it. I'm sure. Can't prove nothing. I don't have a phone. I don't sell drugs. Don't know nobody. Didn't know the girl there. That's what I do know.
I got nothing to do with drugs. I just got out of rehab.
I know that I need a lawyer. I need a chance to get back in court. No crime was committed. I don't know how you got a conviction. I've never even been charged with what I got convicted for. Evidence, the incident report don't match the booking sheet. Booking sheet don't match the testimony from the officers. Robert Downey don't even know what I'm charged with. I can't read that, but if all this is a formality and there's no help, and I told Mr. Calhoun.
So I think his name is Alex Downey, not Robert Downey. But when he said Robert Downey don't even know it, I lost it because Robert Downey would probably be very confused right now if he were here.
I don't even think I should go in this courtroom. Because what judge is going to say this young lawyer didn't handle his business the right way that he knows personally? It's personal. It's 15 years we dealing with. I'm not trying to be rude. I'm not trying to be disrespectful. I need this to be taken up with someone in any other higher court or just put on a newsletter or something. Something's wrong. I don't know what y'all got going on, but something's wrong. And I know I ain't going to get no help in this courtroom because that means somebody in there did something wrong. It's easier to just look at the screen. No crime was committed on February 22nd, which means we're only dealing with a technical violation. If I even had some in my system, if my PO sent it to the lab, it shouldn't even, like, what are we talking about? I don't even know if I had drugs in my system, don't know what drugs, don't know what proof nobody has. Haven't had a motion of discovery, only seen both these lawyers once. Don't even know the difference between them listening to their arguments. Everybody arguing for me. Get me back in court. I beat the case myself because you have no drugs. I don't have no phone. I didn't text anyone. I didn't sell anything. I didn't do anything. Don't sound like no drugs were in my system. Or maybe I put drugs in my system the day before court, or maybe I ate them then and they were rolled over into the court date. I don't know what's going on. I know I need help. And I know I'm not going to get it in this courtroom. So, you know, I don't know whether public defender office keeps sending me the locals. I don't know what to do. So I'm going to figure it out, though. I'm going to keep asking around because there's too many inconsistencies. There's no evidence of nothing. It's just time. 15 years of time, too. I would have been better off getting caught with drugs, probably. I could have went to a rehab or you know what I mean? Stay in the county like most people do. Go to a little handy house and work or something. But it is what it is. Y'all tricked me. I didn't know what I was signing. Alec Downey, he can't even answer no question, but where he came from, you don't know what I was charged with, what we talked about, how long. He's confused. How am I going to have an understanding of my legal representation? He confused. Don't know when, what was signed, where. He can't even answer it. At least I said I was confused before I started talking.
All right. Thank you, sir.
Yeah.
Mr. Downey, anything else?
Is that the end of it or anything? What's the verdict, man? I'm starting to get upset. And what's my next step? What do I do next to get in the court date? Habeas corpus or complaint? Do I have to wait till you leave office or get caught with more charges and bettling?
That's up to you. That's up to you. I cannot give you legal advice.
I'm asking for legal advice.
I cannot give you legal advice.
I couldn't even talk to my lawyer before I came into court. You just rushed me into court again. That's how I got 15 years.
Anything else?
No, Your Honor.
I guess not.
Anything else?
Am I okay to leave or will I be charged with something?
Sir?
Am I getting charged with more time or are you giving?
Not that I know of. No, sir. I don't know of any new charges. I'm aware of.
Judge Reese, please hold him in contempt and give him a little more time.
Is it okay that I leave this courtroom then?
If you wish to, you may leave or you may stay and hear the...
What's the verdict, Judge Reese? Will you let me withdraw my plea? Because no one explained the situation to you and I'm confused?
Please tell me you all know what scrapple is with maple syrup. Please tell me you've eaten scrapple. Please.
I was trying to answer you, Mr. Gates, and you started talking while I was talking, so I'm not going to talk anymore. Any closing arguments?
Briefly, Your Honor. Your Honor, you've heard testimony today that Mr. Gates would not have entered the guilty plea, negotiated as it is, if he had not been under the influence of some type of drugs or alcohol at the time. He has said that he didn't understand it and he doesn't have recollection of that. Judge, we ask that you would allow him to withdraw the guilty plea. Excuse me. You also have heard testimony that if he had seen discovery, he would have not entered into the plea as it stood. He feels like there was ineffective assistance counsel based off the fact that he felt rushed. He felt that there was no discovery presented to him and that he recalls, and that he doesn't have recollections of that day based off of possible drug or alcohol. He doesn't recall entering the plea, doesn't recall, it's my understanding from his testimony that he doesn't recall the plea colloquy, and that he doesn't recall signing any of the documents, Judge. Therefore, we'd ask that the guilty plea be withdrawn. It's required that we have this hearing, Judge, and he is allowed to have a motion to withdraw a guilty plea, Judge. I think that he has presented evidence today in order for the court, sufficient for the court to decide that he did not enter into this in a knowing and voluntary fashion, and that his rights were violated as he has stated previously, Judge.
Palmer?
All right, hold on. Stop. How can you all sit here and say you don't like scrapple because it's pork? Y'all eat pork. I hear you talking about bacon all the time. Y'all eat pork. Pork is delicious. And scrapple is pork. And it's fried, not deep fried, not like in grease. It's fried in a pan. And you fry it and then you put maple syrup on it, or you don't even have to put maple syrup on it. It's pork. It's like bacon. It's delicious. It's like sausage. Delicious.
Judge, the decision on a motion to withdraw a guilty plea is within the sound discretion of you. The standard is whether the plea was knowingly, voluntarily, intelligently made and without coercion. I've heard no credible evidence here today that would be a sound basis for granting the motion to withdraw the guilty plea. I've reviewed the transcript, as the court's already said that as well. There were sufficient facts for the basis of the guilty plea and the probation revocations. In addition to that, Mr. Gates multiple times affirmed his desire to do the guilty plea, affirmed his desire that it was being done voluntarily to you. And I've heard no credible evidence that where the motion should be granted. We would ask for you to deny it.
All right. Well, the court has heard all of the evidence. Likewise, I was aware this hearing was coming up today, so I did review the clerk's file, and I did review the plea sheet, the sworn statement of the defendant, which is, of course, sworn before the deputy clerk or clerk. I'm not sure which that is. By one of the deputy clerks. I did review the transcript as well. And I will note for the record, and I think it's important to note for the record, that although Mr. Gates contends he does not remember any of that, he did a very good job of parroting, that is, repeating what I told him about being a type C recidivist after this plea was completed. He remembered and stated just a few minutes ago that...
Hey, I remember bits and pieces.
Mr. Gates, you don't want to add to your sentence with a contempt, although 20 days wouldn't mean much, but you might want to be quiet when I'm talking.
Yes, sir.
You don't help yourself at all. When I'm the sole person that gets to make this decision, and you keep trying your best to make me mad, but I'm not going to let you make me mad. I'm not going to let you do that. I'm just not going to do that. I'm just going to let you just have all your little fun you want to have.
It's not what I'm here for, Judge Reed.
Anyway, clearly remembers what went on that day, because he, as I said, was able to parrot what I told him at the plea about being a nice evening after this was over with. And also, I find his testimony to not be credible, because he claims he's never even been charged with criminal attempt to commit a felony, when clearly the accusation, which he in fact signed a plea on, clearly charges him with criminal attempt to commit a felony. So his, along with the fact that he claims that somehow the sheriff and the jailers have somehow fed him something to cause him not to understand what was going on. He also complains about getting a 15-year sentence, but of course, because he had prior convictions, at least one prior conviction, although he had two really, he had to get 15 years. He couldn't get anything less. There's no way he could plead to anything less than 15 years, because he's a type A recidivist, and the law requires that he get the maximum punishment for this criminal attempt, which is 15 years. So he would have gotten 15 years regardless, but he didn't get a full 15 years to serve. He got a 15-year sentence with only 5 to serve. and for a third felony conviction that is very, very light in this court. So I do not find there's been any abuse.
Yeah, I tried to rent a table as my home once, but they wouldn't let me. So the largest buffet in America, I believe, is Shady Maple. And I've spoken about this on here before. So you know how you go to buffets and it's like crap food. Like you can see them opening it from a bag and dumping it in and just heating it up. That is not Shady Maple. Shady Maple, like there's Amish women back in that kitchen cooking with love from scratch. And the food is outstanding. And you can go on different days. Well, I mean, you can go on steak day, or you can go on seafood day, or scrapple day. No, there's no such thing as scrapple day. But you do get a happy ending, Fozzie, because you want to know why? There's a gift shop with homemade pastries, whoopie pies, and chew fly pies, and all kinds of stuff. It is the most delicious buffet in the world, and it's right here. It's in Blue Ball, near Intercourse in Paradise. It is. There's Paradise, there's Intercourse, there's Blue Ball. It's in Blue Ball, and it's so good. I go there. I at least go there once a year on my birthday because you get a free meal on your birthday. Oh man, I'm telling you, it is so good. Food coma every single time I go. I every single time. Shoe fly pie. You can't tell me you've never heard of shoe fly pie because that's enough. And all you people still don't eat sausage then if you're going to say you're never going to eat scrapple. Then stop eating sausage because it's almost the same thing.
Any manifest injustice here. I do not find that he has given any credible evidence that he did not know and understand what he was doing. His testimony at the plea hearing was clear and unequivocal. He was asked if he understood all of his rights, and he said that he did. His attorney was likewise asked if he understood all of his rights, and if he'd been over all those rights with him. He confirmed that he had. So I do find that it's a valid plea and is not subject to any motion to withdraw. And I will deny the motion to withdraw the guilty plea.
Man, it's an hour wasted, man.
And Mr. Gates, you may take whatever further action you feel is appropriate, but I cannot give you any legal advice as to what it is. But if you want to hire a lawyer, that would be a good start.
Yeah, probably would, right?
Yeah.
Anywhere but in Marion County.
Well, you hire anybody you want. That's up to you. It's a free country.
That's right. Hey, but you have a good one. I'm trying to wrap this up. I don't want to get no contempt or nothing, but it's time wasted. It's been an hour and a half.
All right. Y'all, anything else we need to be doing in this case?
Nothing further from the defense, Your Honor.
All right. Thank you all very much.
You have a good day. Be blessed. Good luck.
Judge, that's all I.
There was a hot mic moment at the end I didn't want to get, but I do want to. Okay, so they were saying other things, so I couldn't get the hot mic because I don't want to get anybody in trouble. But they were saying, oh yeah, wasted his time. He's got somewhere important to go to, and they kept going on about different things that he's done, drugs, and in his past, and what he has said to the undercover officer. It was so good. It was so good, but it went too far, so I couldn't show it here. I'm not gonna get nobody in trouble. No way, no how. All right, so I recorded the trial. That way we don't have to bumble through and try to find it in Judge Fleischer's courtroom. So we're going to watch a trial in Judge Fleischer's courtroom. So they did jury selection 2 days ago, which I didn't cover here because I hate it. I hate jury selection. So we're just going to go right into the trial today. I don't know, CJ. I don't want to get no one in trouble. I just don't want to get no one. I'm not that person. I'm not going to get clicks and likes at someone else's expense. Nope, not happening. But that part was funny. They're like, oh, Wasted his time. He's got somewhere important to go. Okay. Don't work. Don't work. Tell your boss Kathy said you can go home. Here we go.
Please, all rise to the jury. All rise.
I'm not standing up, Judge. You can't make me.
All right, please be seated. Everyone, please be seated. Like I said earlier, if you have to talk, if you need to do anything, please step outside. We're on the record. We've got a panel here. Okay, state, any opening? Okay, floor is yours.
Not me. I had pizza. I had a lot of pizza.
We're here today to talk about yesterday for a driving while intoxicated case. What we're really here is about a defendant who knew what the evidence would show from the very beginning. And what the evidence will show is what I'm going to tell you now. But before we do that, as I said yesterday, my burden is to prove each of those elements I showed you yesterday beyond the reasonable doubt.
Thank you.
I must prove to you that on or about March 7, 2024, the defendant operated a motor vehicle in a public place while intoxicated. All the elements I showed you yesterday beyond reasonable doubt. You will hear from an employee at a Sonic that the defendant drove that drive-through, struck the property, and asked for an alcoholic beverage. And it is through this interaction that the witness saw it necessary to call police. You will hear that the witness provided information to police that allowed them to locate the defendant and make contact with them. You'll hear that she provided information about his vehicle. You'll hear information that she provided information about the defendant himself. The other people you hear from are the officers themselves who followed up on that information. Those officers, utilizing the information they had from that witness, were able to go to the defendant's residence. And on their way to that residence, they observed the defendant pulling into his driveway. They observed the defendant exit the motor vehicle. And the officers will tell you that they made contact with him as he was walking towards the porch of his residence. And as he was doing so, you'll hear that he had a staggered gait, and walked to him that was slightly, unsteady. He had a poor balance as he was walking. The other thing you will hear from those officers
Venus,
is
thank
that
you.
when they made contact with the
Greg.
defendant, they noticed.
Greg, buddy, you got a membership from the one and only Linus. I hope you appreciate it.
An odor of an alcoholic beverage, as well as his eyes were red, and he had a slurred speech. Following this, the officers saw it necessary to further investigate. You'll hear how they moved him in front of their vehicle to conduct standard testing, at which point the defendant refused to cooperate. The officers will tell you that at that point they took him under arrest, and they will tell you that they read him the statutory warnings required by law before they request a specimen of blood or breath. And again, they will tell you the defendant refused to provide any specimen. Because of that refusal, the officers will tell you that they continued up on their investigation and obtained a warrant to obtain information.
So I got a great trial. I have got not a good trial, a great trial. I don't know why it reminds me of Linus. I don't know why. I can't even tell you why. But it's like 3 hours long so far. All right. The jury is deliberating. So we start at 10 a.m. tomorrow. Well, sorry. We start at 10 a.m. today. So in like 4 hours, the jury's coming back in to deliberate. I don't know how long they're going to deliberate, but trust me when I say if I was on the jury, it would not take long. Um, we got a super controlling, super Christian dad in a war against a gay daughter. And the things he says are unbelievable that he actually is proud of what he says. He says it in court. Um, so I'm trying to think about the best way to put this trial out. I want to stream it tomorrow. It's all going to depend on the jury. I'm not going to bump up against Bill in any way. Bill starts at 8. So I have to be done by 8. So if the jury comes back quickly, then I'm going to stream tomorrow during the day or today, Thursday. I'm going to stream Thursday during the day if the jury comes back early enough that I can get through the whole trial without bumping up against American Courts Live. I'm not touching American Courts Live. If the jury takes longer, which oh man, I just don't think they will, then I might break it into a couple different lives, or I might just do it on the weekend and we won't do Judge Fleischer at all. But I got this trial, guys, and it is really unbelievable. It is a good trial. So I might stream during the day tomorrow, depends on what the jury does. If not, then then I'll do 1.5 hours on Saturday, 1.5 hours on Sunday. But I don't want to drag this trial out like we did with the jujitsu guy. I just want to get it over with. It's really, really good. Deborah, it's okay. You can watch it on replay. It's a great trial. Okay, here we go.
And after you hear from those officers, you will hear not only from the technician that drew the blood from the defendant, you'll also hear from the analyst who actually did the laboratory analysis of the specimen provided. That analyst will tell you how she ran her analysis, how she received the sample to run her analysis, as well as she will tell you the results of that analysis. And she will walk us through the report that she generated following her analysis. You will also hear from the supervisor of that analyst who oversees the operations at the laboratory, and as well will be able to tell you guys the effects of alcohol on the body. She will also tell you how she oversaw the protocols of the report being generated to ensure they comply with the internal policies of the laboratory, as well as there were no evidentiary discrepancies when they made that report. Ultimately, it is, as I said, the evidence will show that the defendant knew from the very beginning exactly what you will see today. And at the end of this trial, I will ask you to find the defendant guilty of driving while intoxicated. Thank you.
Great, thank you.
Yeah. You're not going to like Mr. O'Shaughnessy from what you see very much in this case. This isn't a popularity contest. It's not. This is where the government has to give you enough credible, persuasive, and convincing evidence that proves a person is guilty beyond a reasonable doubt. That they're trying to saddle Mr. O'Shaughnessy with a criminal conviction for the rest of his life. How much evidence does that take? It takes a lot. The reason I say you're not going to like him, You're not asked to be here today to put your green stamp of approval on everything that you see or hear. We know it's not illegal to drink alcohol and then operate a motor vehicle. You can't drive while intoxicated, and that's what they've got to prove. So the reasons you're not going to like some of the things that you see or hear, the one that I think it's going to be very interesting on some of the discrepancies in this case. But they say that Mr. O'Shaughnessy did go, so he has a thick Irish accent, Mr. O'Shaughnessy, you can tell by his last name. He goes through the Sonic drive-through, and they say that he hit the drive-through with his side mirror, and the person calls it in. And they do say, so you're not gonna like that part, that he supposedly runs into the drive-through with his side mirror. And then he does order a Miller Lite, and we don't know if he's serious or if he's joking, and they said something like, why not? This isn't a drink place. You're probably not going to like that. That's not normal. I mean, that's not something you and I might not do normally. Maybe you would. Maybe it's just a sense of humor. Regardless, we're not here on trial today for a person who damaged their mirror running into the drive-through, or a person ordering a Miller Lite from the Sonic. It's not against the law to go to a drive-through and say, can I have a Miller Lite? It also doesn't prove you're intoxicated. There are many different types of personalities in this world, and you will see that. But they've got to prove that those things were because he was intoxicated from alcohol and was driving his motor vehicle. Now, other things you're not going to like are when this is probably going to be a very short case. There's one video. It's not long, and it shows the officers at Mr. O'Shaughnessy's house. He's already at home on his private property and not driving. And they asked him to come over, and we all have different levels of patience or different temperaments. You'll see him start out agitated that he's being asked to come over here, and then he outright he loses his temper and he cusses at the officers. So you're going to see that. He says the F word to him. He tells him to F off. He's not on trial for being really angry about being in that position, getting arrested. I think there's a lot of people that would feel the same, especially if they didn't feel that they were doing anything wrong.
I would too. Anywhere, anytime.
You might know some people like this, but those are the things that you're going to see. Again, being really pissed off and angry at the officers, that doesn't prove a person was driving while intoxicated. But those are the things that you're going to see. So over here, though, is this is DWI. Those are all other things that they're going to try to use to say, we don't like him, we don't like what he did. But how do you prove DWI? And the evidence that you should see, that I'm not sure you're going to, I know you're not going to see certain things. There are three ways: a person not having their normal mental faculties, their normal physical faculties, or being a 0.08 or higher when they were driving. Well, I don't think you're going to hear about any BAC at all. Now, proving mental and physical faculties, that is done by using a series of standardized field sobriety tests. There's an eye test called the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. And by using these three tests, that's what officers are trained to do. You'll hear them testify to this. That's how they're supposed to determine who's impaired and who's not. You're not going to have any of that. There are no sobriety tests in this case either. You're going to hear he smelled like alcohol, and they thought he was intoxicated, so they arrested him. That's it. You're the judges of the facts. Not guilty means not proved. You're going to hear some evidence that you might not like, or obviously some evidence, because we're not here wasting your time. but it's not gonna rise all the way up to beyond a reasonable doubt. All those ways to tell the person is intoxicated, you're not gonna happen in this case. Thank you.
Thank you. Okay, State, would you like to call your first witness?
Yes, Judge. State calls Raquel Castillo.
Oh, Judge, I'd like to go through the
Okay. If there are any witnesses in here for this trial, please step outside. The rule has been invoked. And Alex and Mr. Freed, if you guys see any witnesses, and let your witnesses know, please. I guess whenever we get time, obviously.
Witness has not been sworn, Your Honor.
And if you'd like to come up here to witness stand. If you will please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Okay, ma'am, if you please, take a seat. I'm going to ask you to please speak loudly, clearly, slowly. If your objection, stop. Once we've addressed it, we'll let you know at that point you may continue, okay? All right.
All right.
You ready?
Yes, sir.
Okay, you may continue.
Yes, Judge. Good morning, Ms. Castillo. Can you please state your name for the record? And how old are you? And why are we here today? What type of case are we dealing with today? Okay. And when or what month did the incident that we're dealing with occur?
In March.
And where did the incident occur?
Solid driving, Deer Park.
Okay. If you could please wait until I ask another question to give another answer. Thank you. And what year did this incident occur?
2021.
Okay. And what county is Deer Park in?
Yes, County.
Okay. And were you employed at the Sonic at the time of the incident?
Yes, I
And what were your responsibilities or duties at that Sonic?
manage my store.
Okay. And would your responsibilities have included taking orders at the drive-thru?
Yes.
And was it in the drive-thru where this incident occurred?
Yes.
And was there a certain vehicle in the drive-thru that caught your attention?
Yes.
And could you describe this vehicle?
It was a light vehicle.
Okay. And what type of vehicle was it?
Like an SUV.
And could you describe the driver of the vehicle? I'll rephrase. Was there a male or female in the driver's seat?
There was a male.
A male, okay. And
Melissa, I know you said you don't like jelly beans. Do you like gummies or do you not like gummies?
can you recognize that male in the courtroom today? Looking around?
No.
She said no?
And Ms. Castillo, we did talk about it before. So
Objection, that's leading.
Overruled. Continue.
Could you, just to help jog your memory, what race was the male?
White.
And what approximate age, or could you describe the age of?
Older man.
Okay. And with that in mind, would it be possible for you to look around and observe that male in the courtroom?
Objection, that's been asked and answered already, Judge.
Overruled.
I'll re-ask the question. I'll re-ask it. So with that in mind, could you observe the male in the courtroom?
Yes.
And could you point out the male? Could you point him out by indicating his location and indicating an article of clothing? Or what he's wearing?
Just say don't, you,
Judge, I'm gonna object again. The witness had already asked if she could identify. She said no.
so if you cannot, just say I can't. It's really just.
This is you. Have you testified before? Do you need a minute to compose yourself? Okay. Judge, we asked for a brief reset because she appears to be upset.
Note to all future lawyers, prep your client a little bit.
Recess, a brief recess.
Sorry, I'm gonna object to that, Judge.
I'm not gonna, I mean, if someone needs a recess, I'm gonna allow a brief recess, but
We approach.
sure. No. But I'd like her to answer the question to see if she can identify him or not. If she can't,
She already said no. And I'm sure you need that. But very first they asked again. That's when I checked in. Very first time they asked. When you said no.
I want to just give you ask for the second opportunity. I want to know if she's either going to say yes or she's going to say no.
I can't hear you.
But I also, and that this is not an opportunity for you to go out there and to talk to her. And you know what I mean?
But Judge, my case is falling apart. I need to talk to her for a second.
Just one questioning and then we can.
might go get help, please.
Guys, remember, so ma'am, it's not just, it's either yes or no, okay? Okay.
That narrows it down.
Okay, you may continue.
Yes, Judge. Ms. Castillo, based on your observations and your descriptions of the driver, would you be able to point out the male in the courtroom today and point out an article of clothing he's wearing?
No.
Okay. And Ms. Castillo, so what caught your attention about the vehicle? Or was the vehicle involved in any activity that caught your attention? And what activity was that? Okay. And
Judge, can you give us some more volume, please?
okay. And in addition to running into the drive-through, was there anything else that the male was involved in? Any other things that caught your attention?
When you asked me for alcohol?
Okay. And does Sonic serve alcohol?
No.
And was there anything about the male's speech that you observed?
It was delayed.
Okay. And what was the male's posture in the vehicle, or how was he sitting in the vehicle?
He was slouched over the steering wheel.
And you spoke to the male?
Yes.
Is the person you spoke to in the courtroom today?
No.
Okay. And was there anything about the male's eyes that caught your attention?
They were red.
And was it after interacting with the male that you called the police?
Yes.
Okay. Driver, may I enter the book?
Yes.
States tendering to defense counsel states Exhibit 1 and offering into evidence a business record with accompanying affidavit that was served at least 14 days prior to trial pursuant to Rule 902.
Okay.
Judge, I'm just going to object to hearsay and to relevance since the
It's
witness.
got the accompanying affidavit for the hearsay.
Understood. Just for the record, making those objections relevance and hearsay.
Okay, it'll be overruled. It'll be.
Judge, permission to publish?
So hold on a second. So, all right. So this is States 1, right?
States 1, Your Honor.
And it is what?
It is the 911 call, Your Honor.
Okay, all right.
Your Honor, a moment to fix the audio. All right, I'll just play the audio from my laptop and I'll turn it up as loud as I can.
I just have a question. I'm not sure if this couple is drunk or whatever. They just ran into the sonic wall, like because their car was going. And your partner's on the street? Yes. They just pulled off, trying to stay here for a little while, but they could barely stop it. Okay, what kind of vehicle were they in? In a white vehicle. I have the license, but I don't really know what's on the car. Was it a white? Was it a car, an SUV, a truck? SUV. Okay. Go ahead with the license plate. I'm sorry. Go ahead with the license plate. PK 1486. Okay. He's a top. He's a tall. He's a T 1486. Yes. Okay, you said they ran into the wall at park. They let hit their mirror on like the yard window. And what direction did they go off first? Leaving Sonic or they don't let? So like, do you know which way they turn off center? You know where CBS is at? Where the Senate is? Yeah, we have road. Okay, so they kept going on top of it? Yeah, that's the whole word. You said it was balanced email? Yeah, it's all over couple. I don't know if they're like on the station or what was on. They put up to the window, they asked for like alcohol. Like, can I have a better light? Don't lie on the spot, man. Can I see you there real quick? Yes, please, Raquel. What's your last name? Yes, P-I-L-L-O. I'm sorry. I was pulling off. Is that what's the call number for you? 600-346-491-1803. All right. We just got officers in the area. Thank you so much. Thank you.
Okay, Ms. Castillo. You mentioned that in the call that you believe the couple to be drunk. Was it based on your observations that you believe this?
Yes.
And following that call, were there any officers that arrived to investigate what you told dispatch?
Yes.
And was the information that you provided to those officers the same that you told to call on 911?
Yes.
And by the time the officers arrived, had the male already left the location?
Yes.
Were you able to observe the male leaving the scene in the vehicle?
Yes.
And were you later contacted by other officers about that same information? Were you later contacted again about that information? Okay. That's the way it's going.
Thank you. Ms. Castillo, do you know that the person that asked for a Miller Lite, were you aware that they were just joking? Okay. So this is your opinion of what occurred, right?
Yes.
Right. Just like you said that this person was intoxicated. You never came out, just to kind of paint a clear picture, you never came out of the restaurant, right?
I did.
You never did any sobriety testing on anybody?
No.
Okay, so have you gone through any of that training to like do field sobriety test? Sorry?
I don't know.
Okay, so just like you didn't pick up on that they were joking about ordering a beer, you're assuming that, you're assuming the person was intoxicated from what you saw, right?
Yes.
And you said it was just kind of based on life experiences or something, right?
I'm sorry.
Didn't you say that it was based on like your, like just life experiences or something like that?
Yes.
So it was kind of more like a hunch, like this person, I don't know, they might smell like alcohol or they ordered a beer, you're thinking this person's probably intoxicated, right?
It was running into the window that other reason.
Okay, so the drive-through part of the restaurant,
Yes.
like the part that sticks out the window?
He was not sticking out at the time.
Okay, well, I just didn't know if it, like the windows are flat up against the,
It's flat.
okay. And his side mirror slammed into the drive-through?
Yes.
Okay. And did you witness that happen?
Yes.
You saw his mirror make contact, slam into the drive-through?
Yes, I was standing at the window.
You were there at the window, so you saw it firsthand.
Yes.
Did it make a loud noise?
It did.
Okay. Loud enough that you would assume or you would think it caused damage, right?
Yes.
Okay. And then when this vehicle left the drive-through line or when they left the restaurant, you said that they turned left,
Yes.
correct? And you know that street out there?
They went on to pass me over.
And so if they turn left, that'd be going which direction? Do you know if it's east or west?
No.
Okay. You just said that they turned left, right? May I approach witness? I'm going to show you what's been marked as Defendant's Exhibit 1 through 13. Some photographs. I'd like for you to take a look at those and tell me if you recognize them and if they're true and accurate depictions of what they appear to be.
Hi, Terry. I do not have a drive-through that sells alcohol here. Nope, nope, nope. I wish. A little bit.
Do you recognize those photos?
Yes.
And are they fair and accurate depictions of the Sonic that we're talking about?
Yes.
All of them? All of them? I'd like to tender to opposing counsel and ask.
Micro Psycho, number 1, will you marry me? Oh my gosh, he said yes. He said yes.
That these be admitted into evidence.
Objections.
All right, they'll be admitted. This is 1 through 13.
Judge, do you mind if I publish?
No, go right ahead.
Thank you. Okay, I'd just like to go through these photos and just ask you some questions and then I'll be finished, okay? This is Defendant's Exhibit 1. Is this a picture of the Sonic that you were working at?
Do you mind, hold on, do you mind turning the TV this way so they can also take a look? Ladies and gentlemen of the jury, we also have a TV here. We'll move it so it might be easier for you to see that way as well. Yeah, there you go. Thank you so much. Okay.
So when this vehicle left, did they pull out of this driveway? Do you remember?
I'm sorry.
When the vehicle left the parking lot, did it pull out of this driveway?
Yes.
And then it turned in this direction left, correct?
Yes.
Okay. You're sure about that direction? They turned left? Right? That's what you said on the 911 call as well. So Defendant's Exhibit.
Hey, Bill, are you starting at 8 o'clock tonight? Inquiring minds need to know. Everybody watch Bill tonight. If he starts at 8 o'clock, he'll answer us in a second. There's a delay.
Number 2, there are security cameras, surveillance cameras at the Sonic, aren't there?
Yes.
Do you know how many?
No.
You can see them, and I'm going to show you some pictures, and then point out the cameras, okay? So here's a picture of, is this the side, like, before you go through the drive-through?
That's the entrance side.
Okay, oh, this is good. Okay, so a person enters here, and they would go around the backside and go to the drive-through over there?
Yes.
Okay, so this is the entrance side. And do you see this little white dome right there? You see that?
Yes.
That's a surveillance camera, correct? I'm going to show you Defendant's Exhibit 3, which is a closer shot of that, okay? This is Defendant's Exhibit 3. And same view. And we see that's a camera, correct?
Yes.
And all of the surveillance cameras look like these kind of domes with two lenses.
I'm not sure.
But there are multiple cameras like that around the Sonic, right? There's one, right?
There's cameras on Sonic. Yes.
Okay, so there's one we just saw on the entrance side. I'm showing you what's been marked as Defendant's Exhibit 4. I'm sorry, it is Defendant's Exhibit 4. And what exactly is this a picture of? Is this the drive-through area?
Around the end, yeah.
Sorry?
Around the end, yeah.
Down around this way? And so these signs, we see the back of them right there. That's where someone would pull up in order.
No, that's the dumpster. You pull up the
Oh.
door behind this sign right there.
Right there, okay. Now, if we zoom in, you see these, two white domes up there?
Yes.
Okay, so on Defense Exhibit 5, this is Defense Exhibit 5, this is a zoomed in version of that same location. And you can see a better close up that there's two more surveillance cameras at the drive-through ordering spot, right?
What's your question?
That there's two cameras there.
Yeah, what's that? The picture where?
Well, so I showed you
Oh, yeah.
by the drive-through where they would stop to order. So this is Defendant's 4, right? This is, around here is the drive-through, correct? And I showed you these domes up here.
Yes.
Okay, so this is just a zoomed in version of Defense 4. This is Defense 5. And just to give a better view, you can see that there's two surveillance cameras up there by the drive-through, right? Okay, so now that's 3 surveillance cameras, correct? So far?
Yes.
Defense Exhibit 6. This is the drive-through, right?
Yes.
Or the ordering area of the drive-through, right?
Yes.
Okay. And this is Defense Exhibit 7. It's a close-up of the same location. And you see those, see those right there? There's a camera right there. Right? That's a surveillance camera, correct? And it's pointing down towards the drive-through, correct?
Yes.
Okay, so I'm not going to count those as extras because those were the same cameras that we looked at from the other side. So still we identified at least 3 cameras, but I was showing you the different pictures to show the different angles, okay? Now I'm going to show you Defense 8. This is after they've ordered and they're driving up to the drive-through window, correct? And I know this isn't the vehicle that was there. This is a picture to represent what the Sonic looks like, right?
Yes.
Okay. And so in Defense Exhibit 9, which is a close-up of the drive, where they're driving up to the window, we see that on the wall, right there, this would be the 4th surveillance camera that we've identified, correct?
Yes.
Okay. And that we see that is kind of aiming kind of over this direction it would catch a view of the vehicle going through, correct?
Yeah. Yes.
Okay, so that's 4 cameras. And then now, you said that the drive-through window does not stick out?
No.
That the
Unless
windows
it's
are,
open.
I'm sorry?
Unless it's open.
Okay, I want to show you Defense Exhibit 8 again. I know this is kind of a hazy photo, but I mean, what is all of this structure that sticks out? It's the drive-through window, isn't it?
That's the drive-through area.
Right, so you see like these kind of white posts right there? Or is that part of the window frame?
I'm not sure.
So you see everything from here's where the building is, and then it comes out to here, and then you're saying that there's windows that can open in this area right there?
Yeah.
Okay. But this is something different, correct?
It's all the same building on that.
Right, but where you interact with the customer is between these 2 white things right here, correct?
Yes.
That's where you open the windows, you take money, or I don't know how you'll do that, but you deliver the food to them through this area right here, right?
Yeah.
Rub your
Okay,
TV.
so
Maybe it'll get bigger.
those windows are not flush up against the wall, are they?
They're not what?
Well, anyway, I just wanted to make sure this was an accurate representation. So this part right here that comes from the building out to the service window. This part right here, is that glass that you can see through?
Yes, it's a door.
It's a door.
Yes.
Okay, so there's this whole door right there. Okay. And so you can see people driving through.
Yes.
And you can walk out of that door and you do to serve people food sometimes? Okay, and that door is between the wall, it comes out, and then there's
Victoria, we're doing a trial. You wouldn't have seen this. It's a trial in this judge's courtroom called Judge Fleischer. It's very interesting.
the service windows. So how wide is this? Is this like 3 feet, do you know? Okay. I'm showing you Defense Exhibit 10. Sorry, zoom out. So this is the drive-through window, correct? And so here's where we see this part right back here is where the door is, right? And so the building kind of goes like that, and then a door comes out, and then there's these windows that you serve the food through, correct? Right there?
Yes.
Okay. Now, if I move up here to the corner under the canopy, there's another surveillance camera. Oh, sorry. Right here. So here's the drive-through, and just right above it, there's another dome surveillance camera, correct?
Yes.
So that would be the 5th camera that we've identified, right? And here's Defense Exhibit 11. It's a zoomed-in version of that same view. So this camera is right in front of where the person would be stopped with their vehicle at the drive-through window, right? And it would be pointing at the vehicle.
Yes, it is.
Right?
Yes.
So it would record who's in the vehicle. There's multiple cameras around that could record who's in the vehicle, correct? Like this one's going through it would be looking like through the front windshield.
Yes.
Okay. This is Defendant's Exhibit 12. This is the canopy after the drive-through, correct? So we already identified this camera, and there's actually another camera over here. Have a closer shot. I'm going to show you Defendant's Exhibit 13, which is a zoomed-in version of that same view. But if we look over here, you see those 2 black dots? There's another surveillance camera right there, correct? Okay. So, and that's also pointing towards the drive-through as well, right?
I don't know.
You don't know, okay. So that's 6 surveillance cameras that we've identified. That might not even be all of the cameras that are at the sign, right?
Sure.
There could be more. But we've identified 6 that are angled at a position to record people who are driving through from various locations, right?
Right.
I'll pass the witness, Judge.
Briefly, Your Honor. Ms. Castillo.
Yes.
In regard to the cameras, as part of your responsibilities at the Sonic, were you in charge of surveillance?
No.
And Ms. Castillo, would you know what was or was not reported on surveillance?
No.
Okay. And Ms. Castillo, do you have a clear view of everyone in the courtroom?
Yes.
Ms. Castillo, can you clearly see the face of everyone in the courtroom, including the people at the table to your right?
Judge, I'm going to object to this line of questioning.
What's your objection?
Is asked and answered.
Sustained.
And Ms. Castillo, we listened to the 911 call. In that call, was the license plate provided of the vehicle?
Yes.
Ms. Castillo, can you say today you have a perfect recollection of the face of the driver? A perfect recollection or a perfect memory of the face of the driver you spoke to? Pass the witness, Your Honor.
That's what.
All right. May this witness be excused, subject to recall?
She be excused, Your Honor.
Excused? Okay. All right, man. Thank you so much for coming and testifying, and stay safe out there, okay? Okay. State, call your next witness, please.
Yes, good. State calls Officer Brooks Wash.
Okay.
Well, that was a witness. Yep, that was a witness.
Your Honor, this witness has not been sworn.
Okay. Please come up to the jury. Please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, please. We're gonna ask you to please speak loudly, clearly. If you hear the word objection, stop everything until we address it, and that's what you may continue, okay?
Yes, sir.
All right. State.
Yes, sir. Good morning, Officer Wash.
Good morning.
Can you please state your name for the record?
My name is Officer Brooks Bosch.
And Officer Wash, what is your occupation?
I'm a police officer.
And are you a certified police officer in the state of Texas?
I am.
And what training was required to become a police officer?
Basic BPOC, basic police officer academy training is required to be a police officer in the state of Texas.
And how long have you worked with Deer Park as a police officer?
Currently, almost 6 years.
And what duties accompany your assignment at Deer Park?
I am a patrol officer. I answer calls for service.
And what types of cases have you worked on during your career?
Every single type of case.
And do you have experience investigating driving while intoxicated cases?
I do.
And what training at all was required prior to investigating driving while intoxicated cases?
I'm sorry, say that again.
I apologize. What training was required before investigating DWIs?
In the academy, we go through basic training. We have a 24-hour practitioner course that we take in the academy. I have additional training on DWIs.
And as part of that additional training, was there any special training pertaining to detecting signs of intoxication?
Good news is there is video showing the dude. Bad news is we don't get to see it.
Yes, so of course, in your basic 24-hour course, you're learning signs of intoxication. I have courses in advanced roadside impairment, which is not only alcohol, but drugs as well. I'm a certified breath test operator, meaning I can take someone's breath to see if they're intoxicated. I also have advanced EWI training, and at the time I had over 20 EWI courses under my belt.
And what signs are taught as part of this training?
There are so many signs of intoxication. We are taught that first and foremost, not every person is going to be your fallen down drunk. We're taught to look for things such as slurred speech, red glassy eyes, the odor of alcohol, the way that someone walks or their gait staggers to their walk. We're taught to look for odor of alcohol. We're taught to look for, people not being able to hold themselves up. People
I can't
stumbling,
tell
falling,
you have to wait.
basic drunk-like behavior.
And during the course of your career, have you encountered intoxicated individuals?
Through my personal experience as well as my career, yes.
Okay. And so has this been on few or many occasions?
Many occasions.
And Officer Squash, what type of case are we talking about today?
Today we're going to be talking about a driving while intoxicated case.
And Officer Squash, did you prepare a report for this investigation?
I helped prepare a report.
Okay. And did you bring a copy of the report with you today?
Yes, sir.
And would it assist in your testimony if you could refer to your report to refresh your recollection?
Yes, it would.
Okay. So when you first began this investigation, what was the date of the offense?
Can I refer to my report?
Yes.
Okay. The date of the offense was March 7th, 2024.
Okay. And was that investigation prompted by a call from dispatch?
Yes, it was.
And what information did dispatch provide?
Dispatch relayed that a couple, a male and female, were driving a motor vehicle in the Sonic area. They had come to the drive-thru and were trying to order alcohol through the drive-thru and had struck a portion of the building with their vehicle. They also provided a license plate.
Okay. And what was the address of the Sonic?
It's around the 3500 block of Center Street.
And what city is the Sonic located in?
Deer Park, Texas.
And what county is Deer Park located in?
Harris County.
And what time did this call occur?
I believe it was right around 12:30 in the morning.
And was the call about a possible intoxicated driver?
The call initially came out as a possible intoxicated driver, but the caller was giving information regarding failed to stop and give information for a possible accident as well.
So, officer, what are the first steps in an investigation when you receive this information from dispatch?
The first step was to run the license plate to see if we could figure out who the vehicle belonged to or where the vehicle's registered owner was.
And officer, what information did you obtain when you ran the license plate?
After running the license plate, I was able to determine that the owner was a defendant who I've come into contact with before. I additionally was able to observe the address of the registered owner.
I would object. Just to relevance on what the officer just testified to.
State your question.
Just what information did she obtain when she ran the license plate? And yes, Judge. If you could continue, you were talking about the address. What information did you obtain when you were talking about the address?
Sure. I was able to observe the address of the defendant and noted it to be a place that I had been before.
Objection, Your Honor. May we approach?
Okay. Briefly, please. Wait a second. You're getting into information resolved with this case, right? I didn't hear you. Okay.
I can't hear you, Alex.
Well, I didn't realize that she was talking about prior encounters. I think to me, she's talking about just initial coming up to the car and running the license plate. Okay, just 1 second. I don't want her to get into it if she knows me. But
I cannot hear you.
But I don't want her to get into it. That she's not trying to do backdoor stuff in. I know that you're not. Stephen, can you take the jury out for just 1 second and just hold them briefly outside, please?
All rise for the jury.
Just hold them right there, Stephen, please. Seated. Madam Officer, my only concern is this case. I don't want you to get into anything about any kind of prior knowledge, prior context, anything of this nature, please. Anything, this case, it only resolves what you saw, what you encountered here, that's it. Okay? Anything else that you think that we need to resolve now before I bring him back in?
I object to those questions that come to him. Now, I don't.
But what exactly did she say?
She said, I've known him from previous encounters. I know who he is. And then, how did you know about that address when it came up when they ran his place? She said, I know because I've been to the location on previous occasions. So it's objective to 14, the 6.
Well, I don't think that she didn't say anything as far as like any kind of criminality, right?
Right, but it's a police officer who's had an encounter previously with.
Would you like me to admonish the defendant not to take that into account and disregard it?
That's going to just draw more emphasis.
Right, but
I'd move for mistrial.
okay, let's deny it. You know, I don't think that it rises to the point where it's that kind of error that it would require mistrial. But like I said, if you'd like to, I could admonish the jury not to.
It would do more damage to address it with the jury, so I'm not going to ask them.
But I mean, I'm going to admonish you. If you get into stuff like that, I will. So no, anything about any kind of prior context, whatever. Just, okay? All right. Stephen.
All rise for the jury.
All right, please be seated. State, you may continue.
So, officer, you said you obtained the address, the registered address of the vehicle. Did you go to that address?
Yes.
Okay. And as you're going to that address, did you observe a vehicle heading to that address?
Yes.
And did you observe the vehicle turn into the driveway?
Yes.
were you able to observe the driver exit the vehicle?
I was able to observe the driver at the driver's side door coming up, but I never saw anybody behind the wheel.
And officer, when you approached the address, was the vehicle still running?
No.
Was the vehicle turning off?
Yes, the brake lights were still illuminated as if the vehicle was turning off and, you know, everything was shutting down.
Just like this case is shutting down.
Officer, were you able to see the vehicle pull into the driveway?
Yes, I observed the vehicle pull into the driveway.
So officer, was the vehicle on?
At that point, yes.
And the driver, were you able to make contact with the driver?
I was.
And is the driver in the courtroom today?
Yes.
Can you identify?
I object. That calls for speculation. The witness testified she never saw anybody behind the wheel. This would be speculation.
Your Honor, she says she observed the driver, the person outside the driver's side, and she can state why she believes the person to be the driver.
No. Did she see him driving?
And I can ask you some predicate questions.
See if you can, did she see that who was driving?
That question has been asked exactly in that clear manner. And she stated, no, I never saw anybody behind the wheel. She said she saw a man out in the driveway and the car was off.
She didn't see him drive?
Officer. Your Honor, may I have permission to ask follow-up questions?
Sure.
Officer, is it your opinion that the person you observed was driving?
Objection, that is leading and that calls for speculation. She's already answered that she did not see anybody driving.
Same.
Officer, did you form an opinion as to who the driver was?
Yes.
And what was that opinion based on?
Objection, this calls for speculation, Your Honor.
How?
Judgment of the question.
Sure.
Judge.
Maybe it did.
But didn't she testify that she didn't see who the driver was?
Yes. Unequivocally.
Well, hold on. So she saw him outside.
That's how I am in relationships too.
No. That's not what every time they asked to do it, she said, I never saw anybody driving. I never saw him in the driver's seat. She never saw him in the driving. The other person never identified either.
So let's go back and I'd like you to ask her if she saw him driving, yes or no. Because isn't that the ultimate question? I mean, well, she can't say it right. And I want to make sure that that's what she said, right? If you can't change it, right? It's either you did or you didn't.
I know what you're trying to do, because she said she doesn't even know driving, so I'm trying to ask you no questions to fix that problem, because you have a big problem now. Nobody in there saying this.
Please, let's not try this thing here, okay? Just Alex, ask her if she saw him driving. And that's it. Either she did or she didn't. I don't want to bootstrap. You either did or you didn't. Okay.
Officer, was there anyone else in the vehicle when you observed it?
No, there was not.
And what was the time period between when the vehicle pulled in the driveway and when you observed the person outside the driver's side?
Seconds.
And did you confirm this was the same person the vehicle was registered to?
I did.
Okay. And did the person have the keys to the vehicle?
I don't remember.
And based on those observations, did you form an opinion as to who was driving?
I did.
And who was the driver of the vehicle?
Objection on cause for speculation. She already said.
Sustained.
Thank you.
We'll move on, Your Honor. And when you spoke to the driver, where did you make contact with the driver?
Objection. Now this is objection to relevance, because we've established she can't identify who the driver was. So any questions about what happened to the driver, she can't identify the driver. So I object to relevance. The question was, what did you do with the driver? She didn't identify, she didn't see this person driving.
Your Honor, she has laid the groundwork through circumstantial evidence as to how she formed her opinion as to who was the driver.
This is not a circumstantial game. It's not. And I'm sorry, Mr. Free, you know. Sure. You know,
The detention. In the 911 call, it says if there's multiple people in there. Did you hear that too? Nobody's identified him as the driver. To this, let's take a brief recess. We're going to take a brief recess. Let's take a restroom break. Ladies and gentlemen of the jury, I think we have a couple housekeeping issues that we have to get to. I'm going to give you a brief recess. We'll try 20 minutes, I hope. I've got a lot of people as well, so bear with me. I'm going to try to clean up as much as I can, and then I'll bring you back in here momentarily, okay?
All rise for the jury.
So bear with me, okay? Please be seated. Give me 5 minutes in the room.
It's fine. It's not that hard. Once you get in there and start chatting, it's not that hard.
Okay. Well, I'll just stand back here.
Not yet.
Taking part of your decorations away every time.
I've done it a few times, yeah. I think I actually have some web right now on my.
Hold on.
Yes,
you know, Alex.
Excused?
Yes,
yes.
Okay. You know, the beauty about trial, also the most unnerving thing about trial, is you never know what kind of witness you're going to get. You know, when I tried cases before as a, you know, on the other side, there's two things. You never know how a witness is going to testify. Number one. Number two, you never know how juries will react, what's going to make them happy, what's going to piss them off. And it could be the most minute thing that you would never even think of that just really irks them in such a way that goes against you. So that's what I'm trying to tell you is you never know what kind of witness you're going to get. You know, even if you prep your witness, it's a completely different thing when you get on the stand, because if you've never been on the stand, I have before, because I had a defense lawyer put me on it to testify in a rule invocation problem. I was sweating bullets. I was nervous. I was a wreck. So as you can see, when she was testifying, it's tough. It's not an easy thing. So with that in mind, let's go on the record. I'm going on the record. Did you wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even they state that so they ran the license plate, and on a hunch, they went to, here's kind of the full story. She did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call. But then they go to his house, and
At his house?
They go straight to his house. They don't even go the direction the sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the,
No.
she wrote that in the probable cause affidavit too, that she has encountered him before and she knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Was there anyone in the vehicle when you approached? She said no. She said it was off. And then asked if he had keys to the vehicle. She said, I can't remember. No identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating, or that was the truck, look for the damage on the mirror. They do that.
My only concern
There's
now.
no damage though.
Concern now. Do we have a witness that sees him driving?
Obviously that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you, the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to driving.
you can't get to the admission.
That's what I'm saying. We've got to lay the groundwork there in order to get let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear that there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road.
There's still a hunch. It's a hunch.
Sure. She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house, right? So she's going to, if given the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand that.
Didn't give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why the officers begin. I'm not finished. The Sonic is why the officers begin investigating.
You can't talk when he's talking. I can only take one.
Tyler,
I'm sorry.
let him finish.
Sonic is why the officers initially investigated the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving and that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why?
They recognize and they assume who that person is. There's two people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
So I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the.
I don't think it's relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow. Sorry. I'll dismiss.
Yes, Your Honor.
All right. That's it.
Okay, then I'll follow dismissal, he said. Oh, and that was it. And he said it so quickly and so low while the other person was talking and there was banging that nobody in the chat knew what happened. And for the rest of the whole docket, the entire docket, everybody kept asking, what happened with the case? What happened with the case? Prosecutor filed a dismissal. Prosecutor filed a dismissal. Yeah. No. No, they can absolutely prosecute again if they gather more evidence. Because they dismissed it. So it never really happened. Yep. Cases get dismissed, guys. Right. He wasn't found not guilty or guilty. So the first clip we had today, I think I have a few more of those from today. I think I have a few more, but I can't remember if it was the same judge or a different judge. I just can't remember. I'm going to space them out, though, so that we don't keep watching the same thing. But first, it's 7 o'clock now. In 3 hours. Oh, man. Oh, your comments? Well, Fozzie, were you there? No, Fozzie was there today. I'm joking. I was late. I was asleep. But, that happens. It happens. So I'm going to get a verdict in 3 hours of a trial, of like a 3-hour trial. And it's really good. I just have to figure out when I'm going to play it. If they come back right away with a verdict, which they might, but you know how juries are. You never know. You just never know what's going to happen. If they come back with a verdict right away, I'm going to even I might even have to leave Judge Fleischer's court. I'm going to start the trial today live in the middle of the day, just so that I get it done before Bill starts streaming at 8. So that we can see it all in one shot. It's really good. I just think it's really good. It's infuriating. I don't know how angry I got watching this, but it was up there. It was up there. So just wait to hear this dad speak. I don't know how, like, he doesn't constantly walk around with 2 black eyes, because this guy, we grew up in the 80s, and if you were a jerk, you get punched in the face. And I just don't see why more people just don't punch this man in the face. Yeah, wait till you see what he says to his daughter's new boyfriend. Oh my gosh. Anyway, if you start seeing me streaming early today, that means that jury came back quickly, and that's always a good sign, right? If not, then I'll put it on as soon as I can, because I can't wait to play it. Thank you so much for coming out today and watching this craziness. I will see you in, I don't know, 2 hours, 2.5 hours, 3 hours in Judge Fleischer's stream. And remember to watch April Searing's live stream from earlier tonight, because you will love it and you will curse his name. Do not forget. All right, let's find my outro. Thanks for coming out, guys. Mods, thank you so much. I appreciate it. And thanks to all the members. I really, really appreciate that.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her street sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm.